So, Andrew, today we're talking about Elisha v Vision Australia, which you were saying before you think is the biggest decision for workplace law in the last 12 months.
I reckon it is, Tom. I think that we've seen this case emerging. This happened in 2015, and here we are in 2025 dealing with it through the High Court. But unquestionably, this case changes the way workplace litigation will occur and the arguments that sit around employment contracts. So the old jurisdictions of unfair dismissal, general protections, they'll still be utilised, but this is a way to make a huge amount of money from being terminated.
Yep.
And it means that rather than the traditional employment-based law firms which are skilled litigating over relatively small sums of money, we're going to bring into the field, and this was a no-win, no-fee business that started this. This was a common law business. We're going to see an influx of the Shines and the Arnold Thomas Beckers and people running workplace litigation around termination.
Yep.
And it fundamentally shows you, if you are not careful with the words in contracts, in deeds of settlement, in the manner in which you follow policies and procedures, you're at risk of not tens of thousands of dollars, but hundreds of thousands of dollars.
Yep.
Maybe you could have a bit of a chat and just talk about the facts, because the facts in themselves will say to most people, these are pretty benign. We see much worse things happen every day.
Yeah, of course.
So have a shot at them, Tom.
Yeah, so we're dealing with a man here who had a pre-existing condition, depression and anxiety. He's gone and stayed at a hotel for a work-related trip, and he's got into an altercation with the hotel proprietor, who has said that the altercation made him feel intimidated and this employee was aggressive towards him.
And then the HR manager went and interviewed the hotel manager.
Yeah, and they've got his version of events.
Stood Mr. Elisha down.
Yeah, that's right. Presented him with a letter of allegations, which was specifically related to what he'd been accused of at the hotel.
Which he vehemently denied.
He vehemently denied it, and he said he didn't think that he was aggressive at all. His version of events was different. And unilaterally, the business has gone and decided to prefer the hotel manager's version of events over his. Then they've terminated him based on broader, unfounded allegations, which were related to a history of aggressive behaviour.
Yeah, pattern, they said it was a
pattern of behaviour. Yeah. And basically, they didn't present these allegations to the employee.
But it was their lens through which they looked at the behaviour at the hotel, and once again, that evidence was unsubstantiated. It was impressionistic. Yeah,
definitely. The pattern they were accusing him of coloured their view of the hotel events. Then they have terminated this employee. He has brought a proceeding for unfair dismissal, which was settled out of court.
Now, important here, Tom, because this is the deed of settlement, and these are very customary deeds of settlement which list the types of things which you're saying, and you can no longer have actions brought against you, and therefore in relation to your employment, in relation to your termination. But it didn't say in relation to your employment contract.
Yeah.
And the claim that he went and brought was a breach of contract and a negligence claim in a common law jurisdiction.
Right.
Can I just stop there, because that's really important?
This is unheard of.
Well, it's been done, but psychiatric damages have never been awarded, and there's Court of Appeal law prior to this that said you cannot receive psychiatric damages for a breach of contract.
Correct.
So that's what was before the High Court. It was, can you receive psychiatric damages for a breach of contract? The second argument that was before the High Court was, in negligence, when you talk about breach of duty, is a breach of duty the failure to provide systems? Yes, it is, so that's accepted as law. But are those systems to include appropriate investigation and discipline? What the High Court did is it balked on that, but it seemed to suggest it's unlikely. I'm just saying that's an important part of it, because that's the next step of where the law will go. But let's come back to breach of contract. So what you're saying, Tom, is these are the critical facts. One, had a dispute with a hotel manager.
Yep.
In a work-related capacity.
Yep.
Hotel manager complained, was interviewed by HR. HR did a show cause notice after standing him down for that process.
Yep.
Terminated him then, and then terminated him on a number of grounds never put to him, and which were not substantiated. And behind the termination for the hotel incident specifically was this coloration of unsubstantiated, unsupported allegations about his past aggression.
Yeah, and importantly, I think that the unsubstantiated nature and the fact that these allegations weren't put to him was specifically a breach of the procedure that was incorporated into his contract.
Let's stop there because that's important, isn't it? When we
Yeah.
talk about what is incorporated in a contract, it's not easy to incorporate terms within a contract because it's an express contract. It says what it is. But this specifically said within the contract, you must comply with the policies and procedures of Vision Australia. And what the court said is, if it's good enough for one, it's good enough for the other. If I put these procedures in and they set out a requirement on what you do, and then you as an employer fail to do it, you breach the contract of employment. There's a mutuality in this term. This has been an argument that has been run since CBA and Barker and a whole lot of other High Court cases that have run around the importation of terms. But this is an express term. So do you see already we've got two documents where the lawyers went about templating normal practice. Contract of employment, deed of settlement. Do you see what's important here?
Yeah.
Do you see what's missing from the policies and procedures, which should state specifically these policies and procedures are not incorporated into the contract? All of those things were missing, but I just want you to be aware, if you want to do a brief audit of where your risks are, there's three of them. So Tom, at this stage, High Court's got this case, Appeal Court says we can't do anything with it because there's existing authority that says you cannot get psychiatric damages as a result of a breach of contract by the employer.
Which was an old case they were relying on from the House of Lords, the Addis v. Gramophone one.
Gramophone.
Yeah.
And now you've got the High Court saying, but damages like psychiatric damages, like physical damage, you breach a contract that impacts somebody. It was always in your contemplation that if you breach a contract, you will harm. This guy had an acute episode afterwards and has lost capacity to work.
Yeah, and they said that the existence of the disciplinary procedure was evidence of Vision acknowledging the capacity for a procedure such as that to harm someone.
That's exactly right.
Yeah.
So don't throw the baby out with the bathwater. Don't get rid of disciplinary procedures. Don't get rid of contracts. But look, there are some very simple parts about it. What's the game changer here? The game changer is this. Very significant claims are going to arise for psychiatric damage for termination of employment. You're not excluded from pursuing that by pursuing an unfair dismissal claim because it does not have a jurisdiction to issue damages, either physical damages or psychiatric damages. So you can bring both procedures. But do you see what's going to happen? You've now got plaintiff lawyers who know nothing about employment law, who have no win, no fee and encourage people to come through the door. They're now going to be running employment-related cases, which means there is a whole volume of cases coming towards you, and the first place they're going to go to is the contract. The second place is your policy and procedures. So the solutions are not complex, but the change is massive.
Yeah, I think also it's important to note that the initial unfair dismissal claim was settled for $27,000, which was the maximum at the time. This claim, he was awarded just under $1.5 million. So that says a lot.
So here's the changes that happen. Why is it a game changer to me? One, we've got a whole raft of lawyers who don't practice in employment law who have now been played into the game. They don't have any of the skills that employment lawyers have, and they're not interested in those skills. They're interested in the damages claim at the end.
Yeah.
So that's one thing. The second thing we've got is a High Court saying it is permissible in a time when we're talking about psychological hazards. It is permissible to go after a psychological damage claim, and we've got the Victorian and other state regulators in safety saying if you treat someone badly while they're employed in a disciplinary process, you can be charged with very serious offences, and the Victorian Building Authority is a classic example, charged with reckless endangerment. So we're seeing a bit of a pincer movement that's attacking employment law. Employment law used to sit in the middle and control the game. Now we've got safety law coming in from one side, we've got the common law coming in from the other side, and the risks for officers, for managers, for supervisors go to jail. That's the risk for them. The risk for the business, huge fines, but massive damages claims. Yes, you're insured for those. No doubt about it, you are insured. But the bottom line is the amount of claims, the volume of claims that is now going to come through for breach of contract and psychological harm claims will be massive. And yet the manner in which you
severe
manage
consequences
is so simple.
Yeah.
You develop a policy, the policy is not incorporated in the contract. The contract makes it clear policy is not incorporated in the contract, but there are lawful and reasonable directions that sit outside of the contract which must be complied to, which include the contract. Okay.
Yep.
The disciplinary policy doesn't have obligations on the employer, only on the employer. This mad accreditation process of building manager response, it's all bullshit.
Yep.
Policies are there to stop bad behaviour. Limit it to those people. Now, when you've done that and you're going along to your unfair dismissal claim, think about what you're putting in your deed.
Mm.
Don't just go employment. Don't just go termination. Go all claims arising out of these, including any common law claim. Now, there's going to be a fight at that stage.
You know they're going to try and interpret it narrowly.
But you've got to know it because you've got 3 years to bring your claim to common law. So, Tom, that's why it's a game changer, because we are going to see a huge amount of new claims and they're not going to be run by traditional lawyers.
Yep.
Thanks, mate, for all your hard work on that.
No, thanks very much.
Cheers.